Right, a very good afternoon, East Africa, and welcome to yet another very wonderful and insightful session. As you settle in this afternoon, would like to encourage you to feel right at home and share that link with a friend who has not yet joined the session. Tell them that our session is on this afternoon, and we'll be streaming live on Zoom and on YouTube at our YouTube page at East Africa Law Society on behalf of the entire team at the Secretariat. We are glad to host you once again this wonderful Tuesday afternoon. And as you settle in, we are also glad to have an esteemed panel of experts that have joined us this afternoon from across the region. They'll be sharing their very beautiful insights on the subject matter. And so while you settle in, please feel right at home. And we look forward to your active engagement. Please share that link with a friend and tell them that the session is on right about now. So as we start our session, being legal practitioners, our work, revolves around litigation, revolves around advising clients. And oftentimes we offer advice on different aspects of the law to our clients. But one fundamental question that I may have for you this afternoon is when did you last advise a client who signed a contract by clicking a button? Like we all click buttons. Right now, probably you are there clicking a button advising a client. And when did you last receive or when did you last advise a client whose entire payment structure runs on an app or a mobile phone like we all use? And when did you last advise a client storing customer data in a server that they've never seen in a country they have never visited under the law they do not even know applied to them? And if your answer is recently, or even right now, or even today, then this session that you're joining is actually meant for you, and you have arrived at the right place. However, if your answer is never, then this session is even meant for you much more. And so, as you join in, please note that the digital economy is not coming to East Africa, it's already here. And for too many of our clients, the legal frameworks governing it remain invisible until something goes wrong. And that is what we are here to change today. And to lead this wonderful discussion is someone who has not just studied these frameworks, he's argued them at every level across the region. He's a friend, he's a brother, he's an associate at ENS Kenya, a dispute resolution and tax specialist who has litigated before the Tax Appeals Tribunal of the Supreme Court of Kenya, the East Africa Court of Justice, and he has challenged laws that have violated ESC treaty obligations. He's an ITR World Review recognized fellow, as he was recently recognized as a leading lawyer in tax controversy in Kenya 2025. Ladies and gentlemen, I'm not talking about anyone else but my good friend, Mr. Eli Obegi. Eli, karibu sana, and the floor is all yours. We look forward to a very wonderful session, and you have us until the hour of 4 p.m. So please take this away and take us through this wonderful session. Karibun.
Thank you very much, Gabriel. I appreciate the wonderful introduction. As he has mentioned, my name is Obegi, Eli Obegi. I'm an advocate from Kenya. I'll be leading the moderation of this session this afternoon. The session is largely going to center around advising businesses in the digital economy. We have gathered together a wonderful panel with three distinguished professionals in the sector across East Africa. We have them with us. They'll be taking us through various aspects of the digital economy, including such aspects as intellectual property, branding, trademark protection, data protection compliance, mobile money and fintech, and the regulatory environment around fintech payments and digital payments in general. I'll first start with a round of introductions. I'll start off with Sunday Ndamugoba, who is a partner at Rive and Co Advocates in Tanzania, based out of Dar es Salaam. He'll be our first speaker this afternoon. He's an experienced corporate commercial lawyer who specializes in intellectual property and technology law. And he also serves us at the East Africa Law Society as the chairperson of the Intellectual Property Committee. He's a ranked lawyer with the World Trademark Review and has extensive experience across East Africa in the digital economy and in advising various businesses around those areas of intellectual property and technology. Sunday, if you could just say hello to everyone who has joined us.
Hello, everyone. Good afternoon.
Thank you very much, Sunday. Once I've run through the introductions, Sunday would lead us off with his presentation, which will be centering around intellectual property, branding, platform dependency risks, trademark protection, copyright domains, and risks associated with online presence. Second with us is my senior, Janet Othero. Janet is an advocate of the High Court of Kenya, practicing with the firm of Cavendries. She's a transactional advocate who specializes in technology, media, and telecommunications law, as well as fintech and data protection. She's a certified information privacy manager and data protection officer, and has been recognized by Chambers and Global as a top fintech lawyer in Kenya. Janet, feel free to say hello.
Thanks, Eddie. Good evening, East African advocates. Happy to be in this session, and I hope we'll have an interactive Q&A session once we are done with our presentation so that we can hear all your experiences. Thanks, Eddie.
Thank you very much, Janet. Janet will have the pleasure of speaking to us about data protection compliance for businesses across East Africa, talking specifically around the legal obligations, regulatory expectations, how to deal with consent and lawful processing of data, and how to respond to data breaches. The third with us is my colleague, Julie Ojwaya, who is a legal counsel for M-Pesa Africa, the largest fintech firm in Africa. She's part of the legal and regulatory affairs team at M-Pesa, which she set up and which supports Kenya, South Africa, and 6 other African jurisdictions. She is recognized by on the GLC 500 Power List as a top general counsel and is an awardee of the African Corporate and Government Council's Innovation Award 2025. Julie, please introduce yourself, say hello.
Hi, good afternoon.
Thank you very much, Julie. Julie will take us through our third session, which will center around mobile money, fintech payments, and legal risks surrounding digital payments, their regulations, matters to do with fraud and liability, as well as dispute resolution. So in that round of introductions, I'm just happy to welcome all of you attendees to the session. I will encourage you to engage with us through the chat function and Q&A function. Should you have a question as the presentations are ongoing, please drop it in the chat. And once all the 3 presenters are through with their sessions, we'll have an extensive Q&A session where I'll have the opportunity to pose them to our panel, and we can develop a rich discussion around that. I can see it's almost 4:15, so just to save us some time, I would invite Sunday to come on. and begin with your presentation to all of us. Thank you very much, everyone, and welcome.
Oh, thank you very much, Eli. Good afternoon, everyone, once again. So I'm excited to take you through what is part of my presentation regarding intellectual property branding and platform dependency. So in the interest of time, I'll jump straight in. So I will mainly focus on 6 areas, because when I looked at the risks that are there and looking at the mapping around what the discussion revolves around, I said I will touch on these areas: on the protection gap for MSMEs, look at the trademark strategy, corporate and digital content, look at the domain and platform dependency, touch a bit on data protection, because I feel there is an overlap with IP, of which is key and is one of those risks that are there in terms of registration risks. But then on enforcement and on IP audit, of which I think it's very pivotal for us as practitioners to undertake, especially when it comes to risks. Now, as you will see, technically, in terms of the data that is available, you will see that 90%, for example, or even plus of East African businesses are MSMEs, but 60% is said to now be selling on digital platforms. But the sad truth is that 5% of those MSMEs hold trademark registrations. Not many, because it's more of an informal sector of how it started about, and some are still not formalized. So it's very tricky, and I think that is one of the risks that pertaining to most of East African businesses. So you see, they've been in practice, for example. I mean, they've been operation for more than 3 years. They're putting their brands, for example, on TikTok, on Instagram, and everything else, but they have not registered their trademarks. Even the names that carry their brands, they have not registered those. So that's a big risk. But the risks that I see that are actually there, in line with what has been happening of recent. You see, most of them, they believe perhaps, even though copyright, for example, lies with the creator and it's very automatic. In terms of my experience in Tanzania, copyright is very automatic. You don't need to register it. But then we encourage our clients to register in case of anything in terms of disputes. But in terms of also when we are dealing with the digital economy, everything that goes online has the risk when it comes to copyright. Because for Tanzania, for example, you cannot register your copyright and get a certificate with COSOTA, which is the Copyright Office of Tanzania, without showing who are the right holders in that particular work. So when it comes to apps, perhaps even, so my colleagues will speak more on that, but when we're talking of the source codes, who created, who came up with the software, who designed in terms of the user interface, even though perhaps they worked in the company, but those rights, how did they come about? But in Tanzania also, there's been a recent case which was very, it rocked lots of our clients, because for Tanzania, we are Aripo members, but the Lakairo and Kenafri case opened that gap to show us that all the marks that were actually registered in Tanzania were technically void, because we had not domesticated the protocol. But the good thing is, after the government tabled in Parliament what was called the Written Laws Miscellaneous Amendment, which now had a provision and amended the Trademark and Service Marks Act to include the clause that allows for Aripo trademarks to be operative here in Tanzania. So there is that, of which that is more of jurisdictional risk, but also on platform dependency, which I feel that it is essential, where for those that are trading or doing business online, MSMEs, they interact with the likes of Amazon, Meta, Google, of which they normally would be able, if there is a claim and you don't hold any IP assets, they will literally put you on notice. And I mean, they will suspend you without even noticing you. And then your account will be taken down, of which is a very, very big risk, of which now each one of them has their own way on how you can appeal that process. But also for most that don't know, perhaps those who are practicing in other jurisdiction, in Tanzania we have two systems, which is a risk for most that do not know and they are operating the digital economy. That for Tanzania we have what's called BRELA, which is the registry for trademarks and patents in Tanzania. And we have the law that guides us called Trade and Service Marks Act, which is a revised edition of 2023. But we do through what's called BRELA. It's an ORS system. It's online. And the difference is that we have our own law, but in Zanzibar also they have their own law, even though we're one country. So we have what's called Zanzibar Industrial Property Act of 2008, and they have BPRA. But our term of registration for Tanzania is 7 years, and it's renewable after every 10 years. But in Zanzibar, it's vice versa, 10 years, and then it's renewable after every 7 years. But the opposition timeline is the same. Timelines in terms of you be able to register it takes about more or less the same. So we normally cap it at 90 days. Give or take, depending on if there is no opposition. But also, even though Tanzania is a member of Aripo, Zanzibar is not a member of Aripo because they did not sign the protocol. And so that's the key difference, of which I felt that most would need to know, especially for practitioners, when you're advising your clients who want to cross into Tanzania and operate. Also from the landmark ruling, of which, yes, the legislature came and about and fixed the Rakailo case I spoke about, which was in September, and in 2026, the amendments came about. There's still an unresolved issue, of which I always point it out for practitioners to look into, and clients always ask, because the issue is now, since the marks were there, and then Aripo was considered inoperative in Tanzania in terms of their registrations, in terms of the designation, but the priority date. So the questions were around, is the priority date the Aripo filing date, or is it now the registration date, or is it now after the 2026 when the amendment came about? So that is still unresolved. It's still in wait, perhaps going to be tested in court, or perhaps if there are going to be more, perhaps I would say a guideline from BRELA or from Aripo from that point. But another thing is on, I think it's very important for us as practitioners to know, is on the registration of the right marks and in the right classes, because in the digital space, even though I always advise file a word mark and also file your logo, but in my experience, we've come to realize that word mark is more stronger and adds more value. But if you have a logo as well, if you can file them separately, you have more chances in terms of protection, even though it doesn't negate that when you're filing logo and word mark, logo and mark together and word mark together is not an issue. But also something to point out, taglines, they tend to forget, and they use them a lot for most of SMEs who are operating in the digital space. As long as they are very, very, very distinctive and are not descriptive, it should be fine. But also domain names, most of them tend not to register. encourage them to do the registration. In Tanzania, for example, for any business that is registered here and operating here, as per the law, it has to have a .co.tz. You will be penalized and sentenced if you use anything else other than .co.tz. But for NISE classes, when it comes to trademark, we have classes from class 1 up to class 45 for trademarks and service marks. So for clients, normally we advise for them to go for software apps and that are our downloads, mobile applications for downloads, go for class 9. For those who are doing e-commerce platforms offering services, retail services, go for class 35. And who are doing streaming, go for class 38. And those who are doing training or e-education and the likes, you should go for class 41. And for fintechs, we normally advise for class 36, and anything to do with SaaS or cloud or IT services for class 43. So, but then we normally advise if you can take all the classes depending on the services you're offering, it's always best so that you minimize on the risk. But I have spoken of the automation or the automatic nature of trademarks, but it doesn't protect you when it comes to copywriting in digital content. And the sad thing is, of recent, or I say it's a good thing, but for most, since our laws are backwards, even in Tanzania, we are still in the process of amending them. We are still working over the policy for IP, and then perhaps we get the laws changed this year. AI has taken over. But if you look, for example, in our Copyright and Neighboring Rights Act, Section 2, it defines an author as a natural person. So anything that is generated through AI poses a risk, especially for most MSMEs who are doing content creation, they're posting online. You cannot protect it. So normally we advise better if there was anything in terms of human input prior to the generative or the generation that was done by AI, that in essence can be protected. But the issue would come also in that, for example, when it comes to the fact that for anything that has to be protected, it has to be tangible. Okay, so there is that. There's been a narrative around also social media videos and podcasts using background music for commercial purposes. That also has to be protected. You have to make sure that there is a license. COSOTA used to collect royalties, but now that was done away with. Now COSOTA is more of a regulator, but we always encourage our clients to do so and have clearance in terms of the usage. We have been having issues with clients that perhaps tend to believe that once you have content created, even if it's a company, that means you have automatic protection, which is very, very bad and very sad. For example, when we are talking of what clauses you should always include in your agreement, we always insist on the key IP assignment clause, of which that will say all IP created under this agreement is assigned to the client on payment of full, perhaps including copyright, trademark, database rights, and everything else relating to that. If it's in writing and it's put down, that protects your clients. But also, if there is any pre-existing IP licenses, it has to be mentioned in the contract that those are also incorporated in deliverables and they are non-exclusive and perpetual. So that also has to be put in place. You have to make sure that, because there was a recent issue where I was talking to a client, they were complaining they had someone who came in, I think from Ghana, who was working in that company, and they developed a software. But that guy, even though he was employed there, insisted that that software was his. You see, that was an issue because there was nothing to detail that everything that you do belongs to the company. So even if it's work for hire, it has to be declared, it has to be there. And warranties and indemnities have to be there. If you are contracting out to another company to do so, they have to be there so that you don't infringe any third-party rights, perhaps if that contractor to make sure that all of that
We appear to have lost Sunday's connection. We'll just give him some 2 minutes to sort out the gadget and get back to us.
Yeah, Ellie, in the meantime, while we wait for Mr. Ndamgoba to join us, for friends that are joining us across East Africa, it's a privilege to have you here with us, and karibu sana. We are in the middle of this very wonderful discussion, and I think, Ellie, we can proceed with our next speaker, and when Mr. Ndamgoba comes back, we'll just continue with the conversation.
In the meantime, for all the attendees who are here with us, I encourage you to drop any questions you may have, any insights you may have in the chat. And then we'll have our esteemed panelists address all of these questions and insights in the panel session we'll have soon after the presentations conclude. Janet, you're with us. I think you can go ahead with the next phase of the presentation.
Thanks. Thank you, Ellie. Welcome, everyone. I'm going to be covering the session on data privacy. I see Sandy is back.
Sandy, you want to proceed?
So sorry about that. Sorry about that. Let me see. Okay, where was I? Okay. Yes. Let me be quick about it. 1 minute. So yeah, I think so. Another thing I feel we need to always remind our clients they need to treat their domain names as their pretty much their title or their land titles, because of cyber. When we speak of cyber squatting is when a competitor registered a brand and then they demand a transfer fee. So when you want to register it, you find that someone else has already registered in your state and they will demand so. Or someone will do type of squatting where they are being redirected to them without you noticing. So there is that as well. So even though you can go through the disputes routes under UDRP, where they would look at in terms of defense if there is no legitimate interest, if there is registered in bad faith, but also they would look like if it is anyhow confusing similar to the domain name that you have. So it's always important to do so. Even in Tanzania, mostly we encourage our clients to do so. We have TCRA, which normally looks into disputes that pertains to that, but we say always register your domain, register your trademark. But one thing that most of our clients forget is what I call the platform dependency. We see, for example, all of these ones, the ones that I've listed there, from Amazon to Apple Store to Meta, each one of them has their way of making sure that in case of anything, it's very easy to terminate or to make sure that you are held responsible. So in case of a competitor that perhaps comes in and reports you, or a client reports you, or if it happens that it's the government that has reported you, which has happened in Tanzania, the most idea we tell our clients is make sure that for each platform that you operate on, you know how they operate in terms of termination, so that in case of that, in terms of takedown, so that if you are taken down, you can easily now go back and say, I have this to claim, no, this is not what happened. This is how it's supposed to be. And how do I defend that? So For example, if you look at TikTok, for example, if there's a copyright issue, normally within 24 hours, but there'll be a takedown, but there will be an appeal process that has to take place, but it depends with each and every jurisdiction because it's very different, so to speak. But even if, for example, if you go to Meta appeal could take 5 to 14 days, which is very different from the others. For example, if it goes to Amazon and then you complain or you make your case, for example, if there is an IP complaint, normally within 24 hours, they would be able to reinstate you. So each platform is different. So we always say before you do anything, before you go live, they need to register so that they can minimize the risk. Your brand has to be, you make sure that it is protected and you register it with the particular platforms that you're operating on. If they require you to do so, please do. So that means if you've registered it with the regulator, that means it's easier for you to do with the platforms. But also there is this question of client relationships. It's very important that you have that within you. So if you have a proper CRM, proper website, make sure all those channels you own them. But then again, make sure that the terms for your clients, to make sure they read and advise them on those platform terms, as I had previously mentioned. But in terms of to counter now, if you've been taken down, those templates for notices, make sure that the client has for each and every platform, so that it's easier for you to know the appeal process. Most of these digital platforms, they're doing them online. Some you can fill in, some of them you have to upload with evidence, but at least if you know in case of this takedown, what should be the response, you prepare your clients so that they can avoid that risk and it adds value to them. But also I had mentioned the platform indemnity clauses. Always have that with their suppliers, with the influencers that you use, content creators that they use. They have to indemnify your client in case of anything that leads to the content. In Tanzania, for us, there's a big issue even of, I think 2 days ago, they made an extension. There is what we call the Personal Data Protection Commission, which made an extension for people, for institutions to register, even though a lot have registered, but for registration to take place, but also cross-border transfers that has to be there, you have to be permitted. So for most SMEs that are using data transfer, that is a very big risk in terms of jurisdictional approach. But their customer base, how do you protect it? It's very, very important, because that can happen a lot when, it can happen a lot where an employee leaves you and then leaves your data or exposes the data. There could be a breach possibly. So there is that. But also to know when it comes to personal data, you're protected in Tanzania mainland and in Zanzibar, even though, but it applies union wide. So it's very important to know, even when it comes to trademarks, patent copyrights across East Africa, everywhere is different. You look at the laws in Rwanda violated there, in Kenya, in Tanzania, in Uganda, in Burundi. They're all different, and they all have their level of protection. Even though we say, if you look at Kenya and Rwanda, they're a bit ahead. Tanzania and Uganda, I would say not so much, but we are getting there. I feel it's a very jurisdictional risk. But the cross line I mentioned prior, in terms of the emerging frontiers, AI and IP, I feel like the law gets caught. For example, when it comes to AI generation content, we said there is no author as per our section 2. But there is a recent issue where it comes to voicing and likeness cloning, which now a competitor can use AI clone to do voicing or deep fakes for promotional purposes, and then there's nothing you can do. But what we looked at is that it's very easy for you to rely on passing off, of which that could protect you in our jurisdiction, especially if you have registered already. But on data training and scrapping, that also is an issue where a website content is being scrapped without consent of the training for AI, of which you should advise your client to do what we call anti-scrapping terms of services. And if you can, perhaps timestamp and watermark the images so that they not be taken, of which that is a software. There are softwares that are available to do so. But in terms of AI trademark examination as well, we know that Aripo and Kipi have been told they're using AI to do trademark examination, of which now this means they can easily refuse a mark if it is perhaps within it's been registered already, or it's within their database. That means whenever you are advising your clients, make sure that whatever they are bringing to the market has been searched and they know that they own it, because now compliance is very key. That means we are the distinctiveness in terms of protection is very pivotal, because AI tools will pick it up very easily moving forward. So I think it's very important to do so. In Tanzania, platform taking down has been happening, but also FCC recorders, now it's a big issue, especially for SMEs that are operating on the digital space, but also have products that move between markets in Kenya, for example, in Tanzania, whereby you can, if something that comes in across the border and you've not put your trademark certificate with FCC and the border, then you suffer issues in terms of importation. But I've looked at cases that cut across digital IP and what's happening. I've spoken of Lakairo and Kenafric and what that meant in terms of protection for IP and for SMEs that are operating in across jurisdictions and when it comes to registrational risk. But also I've looked at the Nixon case, which was recent as well, where the court found for the plaintiff. It was a case in terms of the distribution, the content that was hosted on a platform by Airtel. There was an agent that was involved. So there was an issue whereby digital platform operators were told to always obtain licenses from the content creators or the hosts, or the ones that they host. But I saw a case in Uganda as well, where there was an award in terms of using collections without consents. And the famous Robertine case, where it was decided between when you are doing and when you are showcasing your products perhaps online, and what you're going for is the red soul and the shape of it, of which now is very key in terms of what you are putting out there and not copying what someone else has done, because that was something that was already protected as per the Paris Convention. Color and the shapes and the position are very distinctive and they are protected. So I say always, for you to advise your clients, always identify. I put it in 3 phases: identify, verify, and protect. So know the brand names, domain registered software apps, the content you're putting out there, know which licenses are with the third parties, then verify, search, register, and the protection that comes after in terms of now updating all the contract that you have with suppliers, in terms of your calendar, how you are renewing your marks, your trademarks and the likes, so that you don't miss out. So I would say for every practitioner in this room, make sure you file in both jurisdictions if you are operating in Tanzania, or you're advising your clients to come and register or to come into a market entry like this one in Tanzania. You have to make sure that they register in Tanzania and Zanzibar. The Aripo effect that happened, now we have a law in place. So now that has now taken things back to the original how they were in terms of registration. But also I encourage you to tell them to do their IP audit, so that at least if you can spend time with your clients to make sure that they look at the trademark gaps, which ones they own, which are the trademarks as the IP assets they have, where are the ownerships, where are the exposures, and where is perhaps the dependence on the platforms, and how now they can be able to be sure that in case of anything, it doesn't fall back on them. So I'll leave you with the fact that I believe every digital business has to have an IP, But the question is not whether your clients own it. They all do. But also the question is whether it is protected. So that's it from me. But I want to have it upon you to make sure that when you speak to your clients, they look at what I've just presented in terms of ownership risk, in terms of the registration gap risk, in terms of jurisdictional gap risk, in terms of platform dependence risk, and the contractual or contract risk. And lastly, as I've spoke of FCC and umbrella, in terms of enforcement risk. So I'll end up there and invite questions should they come in later. But in terms of risk, as far as IP is concerned for digital economy and MSMEs, that's it from me. Over to you, moderator.
Thank you very much, Sunday, for that fantastic presentation. It was quite insightful. I'm sure there are a lot of reactions to it, which we'll deal with when we get to the Q&A session later on. For now, I'll invite Janet Otero to join us with her presentation, which should be centering around data protection compliance in East Africa.
Thanks, Eli. I'll try and take 15 to 20 minutes with my talking points. So SMEs, MSMEs are basically a good number or a good majority of entities that operate within the East African space. And most of them are spread across various entities, from trade being the biggest and manufacturing, to some of them involved in agriculture, technology, financial services, and also a good majority of them in construction. Now, what you'll notice with most of these SMEs and SMEs is most of them operate in unregulated spaces and have operated in unregulated spaces for a very long time. And just like Sandy said, some of them do not appreciate the risk that comes with legal compliance. And because they've always operated in a very gray area, whenever there's emerging legislation or emerging regulation that forces them to get their house in order, they tend to be the ones who fight it most or do not comply until there's a situation or there's a crisis that they're facing, is when they start working backwards towards looking at compliance. So when it comes to data privacy for SMEs and MSMEs, again, most of the data protection legislation within East Africa do not categorize, other than the filing fees, do not categorize any difference in terms of obligations, such that if this obligation on registration is there, it applies to all. If there's an obligation on recruiting and hiring a data protection officer, it applies to all. So we look at some of from a very executive summary, some of the obligations that these SMEs need to be alive to. And one of them is that most SMEs need to be able to understand the data life cycle of all the personal data and even just any data they collect, process and store, and maybe eventually destroy. SMEs are most of them are informally started. Some of them may be formally started. A good number of them may be family owned, passed down from generation to generation. A good number of them may still have one founder running the SMEs, or a group of friends, or individuals who came together with a common purpose. And because of that, they've operated on the basis of, if there's nothing wrong, then I don't think we should stop at this point and look at what's happening. So when you're looking at data privacy as one of the compliance requirements, it's important that you are able to understand the life cycle of any data that you collect. Is it employee data? Is it customer data? Is it third-party data? How do you collect it? How do you process it? How long do you stay with it? And does it present a compliance obligation on us, or does it not present a compliance obligation on that? Once you're able to map out that sort of situation, then you'll be able to know how to approach your data privacy and compliance framework. Then also it's important to know and understand what it is you're doing as a business when you're collecting this data. Do you have a digital strategy, a digital business strategy, or are you operating on a strategy that does not look to leverage on digitization, digital infrastructure, and data, and most especially personal data? So once you're able to understand the kind of environment you're operating it and it leverages on a lot of data, then that's when you ask yourself, are we within the legal requirements of collecting and processing this data, or are we not? And that's when we talk about the lawful basis that people are supposed to comply with when processing personal data. Lawful basis being the basis of consent, vital interest, public interest, legal compliance or legal obligation, and also legitimate interest. So are you within those parameters when you're processing this data, or you're processing data because it's routine, it's custom, it's how we've done it over the years? Apart from that, there are also the principles of processing data, which you must use as a bedrock or as a foundation. So are you looking at the principles of accuracy? Are you looking at minimization? Are you looking at transparency? Are you looking at data integrity? Are you looking at accountability? Are you looking at all those principles, or you're operating because it's my organization, we are the board of directors, we are the founders, then we don't need to be answerable to any of our customers, to any of our partners whenever we process their personal data? Then it's important, depending on the sector that the SME is operating in, to know what kind of data subjects it deals with. Are you dealing with adults? Are you dealing with minors? Are you dealing with people who are considered minorities, or sensitive? You're processing sensitive data. The reason you're trying to understand the kind of data subjects you're dealing with is to be able to enable you put together a data subject request access matrix, or an escalation process, or a register that is able to answer to a lot of these data subject requests. So do you understand whose data you're processing, what categories they fall in, and looking at the analytics or analyzing previous requests, are you able to come up with a framework or a register or an escalation matrix in terms of dealing with these routine or regular data subject requests? Remember, a good majority of the complaints that always end up before the regulator are usually data subject motivated. So do you want to be an organization that is always in front of the regulator defending its data processing activities based on multiple data subject complaints, or are you somebody who wants to be proactive and put in place a framework that will be able to take care of this? Then SMEs mostly play the role of suppliers or outsourced services, but they themselves also outsource services and have other suppliers. So in this third-party arrangement and in this third-party ecosystem, what role are you playing? Are you a controller, and are you also a processor? If you are a processor to many entities, then what sort of safeguards have you put in place to be able to deal with these people? If you are a controller, then what safeguards have you put in place to deal with these people whom outsource services to you? How do you onboard them? How do you audit them? How do you do due diligence on them to make sure that they are compliant with the requirements of the data privacy legislation, thus giving you a level of comfort that you are also compliant? If you are an outsourced service, whoever you are supplying your services to, how are you ensuring that they are compliant? And if they're not compliant, it doesn't mean that you also become lazy and become not compliant. What can you do on your part, and what can you push on them to be compliant, so that in the event they face any regulatory action or data subject action, on your part, you're able to limit your exposure and limit your liability because of the protocols you put in place in your contractual arrangement? Then, like Sandy said, there's a lot of automatization happening of data, a lot of commercialization. We're using AI, we're using digital tools that are able to make our work faster, are able to do repetitive tasks. We are using a lot of AI to just narrow down and work smart on various aspects. But we are feeding a lot of personal data. Commercialization, we are sending out bulk SMSs, we are sending out emails, marketing emails, we are making phone calls. And all this is commercialization based on the personal data we may have collected for one reason or another, and the client opted in. So again, with most regulations, you need to ask yourself as an SME or somebody supporting an SME, what protocols or what safeguards have we put in place whenever we are leveraging on automated tools such as AI? What protocols or safeguards have we put in place whenever we are doing direct marketing to make sure that we are not infringing on data subjects' rights? Are we putting out opt-out options? Are we putting it very clearly and legible? Are we denying them services because they've not agreed to opt in? What are we putting as a balance in terms of just furthering our digital business strategy and also complying with the data privacy laws when it comes to dealing with personal data for marketing and commercializing? And also, we can't ignore the fact, like Sandy said, there's a lot of scrapping of data on the web where people are able to get data and actually use it for analytics to be able to push certain products or profile people. So again, what are we advising these SMEs when it comes to scraping data from the web and using it at targeted advertising or targeted profiling towards individuals? Are they putting in place protocols that ensure they are able to show the chain where they acquired or collected this data, whether it was direct or indirect, whether they observed the principles, whether they used the lawful basis, but whether they have the consent to keep on profiling or approaching these data subjects, and whether they're doing it within the confines of the law or whether they're doing outside the confines of the legal provisions. So again, data transfer protocols, a lot of SMEs will definitely be outsourcing services locally. Like I said, some of them have capacity to outsource services globally. Regionally, they will be trading with other companies or other suppliers. So when it comes to transfer of personal data from a regional and from a Pan-African and from a global perspective, what have they put in place in terms of what their local laws require them, what regional laws require them? Are we looking at whether we can do this within contractual confines? Are we looking at involving the regulator to give a consent or an advisory? Are we looking at whether there are existing regulations in the other country? Are we looking at whether we have the consent, whether the safeguards are in place to be able to transport this data? Then what assurances are these suppliers giving us whenever we export our data? Because even exporting data may just be as minimum as storage, maybe as minimum as organizing payment transactions across border, and all these have a level of personal data crossing through the borders. So what are we telling our SMEs and MSMEs towards compliance in terms of, do you have data transfer checklists? Do you have data transfer protocols that are able to tick the box in terms of what your minimum national legislation requires from you? Then the biggest issue currently facing a lot of SMEs is security breaches and data breach incidents, where it's either trade secrets or operational data that is lost, but at the same breath, sometimes personal data is lost. Like I've said, a lot of these SMEs are not keen on compliance, especially given how they started and how they've grown, and if they've been operating in a very unregulated sector. So it becomes a bit hard for them to deal with a data breach, which has regulatory concerns or regulatory compliance steps, and they've never known how to interface or interact with a regulator. Do they understand the minimum timelines for reporting? Do they understand the templates that they need to use for reporting? Do they understand the relationship they need to have with their shareholders and stakeholders when it comes to reporting and mitigating breaches? Do they understand how they will liaise with the regulator to be able to mitigate this breach? Do they understand the role of law enforcement and investigation agencies when it comes to assisting them with mitigating and managing these breaches? Because most of them are used to dealing with issues in-house from a reputational perspective and also from a cost perspective. They are not really keen on blowing up issues if they can make it go away using internal mechanisms. So again, and just to ride on what Sandy said, a lot of them may have ICT policies, information security policies, ICT and information security procedures, but that is not enough, because ICT and information security may govern infrastructure of the organization and other types of data, but they may not necessarily be attuned to the requirements of personal data. So there's a need to go back and look at those ICT and information security policies to make sure they align with the minimum data privacy requirements, or implement and put aside policies, procedures, and checklists that govern data privacy, but ride on the existing information security policies and ICT policies within the organization. So looking at SMEs and what are some of the challenges they face towards compliance with any regulation, and data privacy being one of the emerging ones, it's because, like we've discussed, governance issues, how they started and how they've been operating, whether they've been looking at growth and how they've managed their growth, and whether their boards have capacity, whether their hiring is skewed towards building capacity, or it's just been hiring to fill in the gaps without capacity. And when it comes to professional service provision, such as data privacy, if they don't have internal capacity, they can always rely on external service providers in the same way they would rely on external auditors to offer these services on a retainer basis or even on a case-by-case basis, project-based sort of thing. And because most of these circles are usually understaffed or have minimum staff, it becomes an issue to hire somebody or recruit somebody internally. So external outsourcing may be seen as a way. Again, given the operational expenses we are seeing for a lot of businesses within the region, a lot of them may not see the importance of making financial investments, for example, in technical tools that can help you achieve data privacy compliance, and even in external service providers. So with that being the scenario, most of them choose not to adopt compliance mechanisms until the regulator comes knocking. Then looking at how a lot of the market has shifted to digital use of digital tools, digitization, digitalization, SMEs are not left behind because a lot of them are adopting and looking at digitizing their processes or digitalizing what they do, their systems and their operation methods. And with the digitization, you cannot ignore such things such as cybersecurity incidents and data privacy. So it is important that as their business strategy evolves and they look at digitizing and digitalization, data privacy compliance should be one of the key issues that they make a budget for or make a resource for. Then we are also looking at poor cash flow, or other tax may have been a bit too burdensome, lack of investment, and with such priorities faced to SMEs, then most of them opt to actually keep the business alive with the little cash flow they have, with a lot of the burdens they have, and data privacy takes a back end because it's one of those things that's more of a preventative, good reputation or look on the business than it is a core or a fundamental operating aspect. And that's the narrative we need to change with them, especially because data is now sitting as an asset for most organizations. And if properly harnessed, properly used, ethically used, a lot of these data sets can prove invaluable for a lot of company operations. Then also SMEs do not have standardization requirements in the same way a lot of big entities will always opt or follow market standardization. And this is because of the nature of the operations. They need to either have the ISO certifications or they need to have the global affiliations to show that they have standardized their operations. And SMEs do not feel this pressure or need for standardization or market standardization. And that's why it becomes very hard to have very hard and difficult to have conversations on compliance with the Data Privacy Act. Like I said, SMEs are also very risk averse. They tend to be risk averse. Anything that they choose, they do not understand or do not have an appetite to understand and break down and see how it's important to their business. They will quickly shun and not adapt. And in such a case, data privacy within the regions is becoming one of those things that's now becoming a reputation item to have, because any partner you deal with, any global or local region partner you deal with, one of the key highlights or documentation they're asking for is to see whether you have a sound data privacy framework. And so this cannot be one of those risks they push away. It has to be one of those that they adopt fully and they are able to just adopt. So in conclusion, what I'm trying to say, when dealing with SMEs and MSMEs, whether you support them or work with them, data privacy cannot be seen to be sort of a reactive compliance obligation. It needs to be proactive, because one of the things that all regulators will want to see, apart from it being documented, apart from it being just a checklist, they'll want to see the culture of the organization as having adopted data privacy processes, data privacy compliance, data privacy maturity. They'll also want to see whether how you deal with your customers and your stakeholders embodies a level of data privacy compliance. So it can't be a matter of just having documents there. It has to be something that is alive and attuned to the organization's operating models or business strategy. And at that point, I will stop, Ellie, and cede the floor to the next speaker.
Thank you very much, Janet. It was a pleasure to hear from you. I would like to now hand over to Julie Ojwaya to take us through the next session on mobile money and fintech.
Hi, everyone. Good afternoon. Just a minute.
Hello, welcome, Julie.
Sorry, I was just responding to Janet's LinkedIn post for this session. Okay. Let me know when you can see my screen.
Loading. Yeah, we can see it now.
Okay. Okay, so I'll be talking about mobile money, fintech payments, and legal risk and digital payment ecosystems. Just bear with me. There we go. Okay, so I speak based on industry experience because I practice in this industry. Let me just say I practice in payments, fintech, and technology, and that has been the bulk of my practice years. So I speak as someone who is in the industry in-house. So we have digital payments in East Africa that are growing rapidly. We have very many entrants that are coming. 10 years ago did not look like how it looks like today. And I'm sure 10 years from now will not look like how it looks like today. So we have very many players that are coming in. We have players that are coming in from technology only. These are guys who are building platforms and selling out those platforms. We have guys who are building platforms and inviting customers to interact with them. That's where you get the B2B stroke B2C kind of players in the market. You also have banks that are now entering into the technology space and having their own fintechs in-house. And you also have techs that are emerging from the kind of telco-based businesses that have been there for a while. So we have roles that are blurred between who is a bank, who is a fintech, who is a telecom, because it seems like everyone is doing the same thing. And most importantly, everyone is going after the same customer. So how does the industry then play together with the regulations that we have in place? I've talked about the ecosystem players that we have. We have aggregators. We have a lot of aggregators in East Africa. You have the players who would go to the regulated entities, obtain the services, and then sort of give a customer who would be a merchant or a B2B2C type of customer marketplace where they can be able to get services and offer a conglomerate of services to a customer. We have then the merchants themselves, we have agents, we have the schemes, of course, who play a very key role, especially for card payments. And then we have the regulators who regulate the industry. So as we get into the session today, we'll be looking at the various regulatory frameworks that we have in East Africa. We look at the central banks, we look at the various authorities that we have. We have the laws that back this type of engagements and the type of players that we have, where we have the national payment systems laws in Kenya, Uganda, Tanzania, and then we have various other laws in the other East African countries and cutting through Africa. So we also have the licensing of PSPs and fintechs. How can you get licensed? What are the requirements? And then we go into AML and CFT, which is a really, really big thing in payments. AML is anti-money laundering, CFT is counter-finance terrorism. And this play a very, very big role if you're moving money or you're in payments in the whole region. So these are things that regulators are usually very, very much concerned about. And then we have safeguarding of customer funds and data protection laws. So I start by fraud risks in digital payments as one of the topics that I was asked to speak about. Fraud is a really, really big risk in payments. And we see that fraud is also an emerging trend, because then we have a trend upon trend every other year when we go along in payments. So before we did not have issues like SIM swap fraud. Now we have a lot of SIM swap fraud that is happening and impacting payments, impacting different players. For example, you might have a bank that has a mobile banking platform where a customer can be able to deposit or withdraw cash out of the mobile app, and that SIM card belongs to an MNO, and the SIM is swapped and funds go missing in the customer's bank account. So we have a lot of interdependencies that are going on. So as an industry, it really behooves us to be able to play together, share insights, and ensure that we secure the industry together. We have unauthorized transactions. Maybe it was due to social engineering, or it was due to hacking, where someone can be able to access someone's store value and penetrate the safeguards that they have and be able to access the customer funds, and therefore the customer ends up being defrauded. We have agent and insider fraud, where you've hired someone to manage your business. Maybe you do an agency type of business for an industry player, be it an MNO, be it a bank, and the person ends up doing some insider fraud and defrauding you of either your float or defrauding the customers that visit your agency. We also have merchant fraud risks, and this is a big one. Previously, when I was dealing with card-related transactions, you'd find that immediately someone launches an online payment scheme or an online payment service as a payment provider. And this would be the likes of, you've seen Pesapal, you've seen Cellulant, you've seen DPO, just mentioning a few that we have in Kenya. Immediately someone goes live with that platform, the next thing you'll hear is that there was fraud. And there are people who monitor these online payment providers. And because the assumption is that by the time someone is launching, maybe they've not sized for scale, or they've not put in the proper safeguards to safeguard their online business. So therefore they get hit with a lot of attempts of fraud. And here you will get industry players getting issues like cards issued in the diaspora, either Europe. You also find cards issued in the United States now coming to perform transactions, looking almost like legitimate transactions, but end up being fraudulent transactions. And this is simply because cards there don't have the requirement to have 3D Secure, which is a 3-layer authentication framework, the way most of the players in Africa have. So you have a card that you just need the card number and the CVV, and you don't need the OTP to be able to authenticate that transaction. And those are the cards that you see. You went live at 8 a.m. Between 11 p.m. and 2 a.m., you get 3 times the transaction that you've seen in a week, and all of them might end up being fraudulent. So a lot of that happens, especially on card transactions. Then we have weak authentication vulnerabilities. Even for merchants that are here in East Africa, we have systems that allow for 3-factor authentication, but some merchants don't want to make that investment, so they end up getting hit with a lot of fraud. Then you have the issue of chargebacks, and chargebacks is just how the scheme defines how a customer can be able to lay a claim. So if I, Julie, go to an online platform and pay, if I feel that I'm not the one who paid, or I did not receive the service that I paid for, or I did not receive the product that I paid for, I can go to my bank that gave me the card and request for that transaction to be nullified. And then the scheme will follow the protocol and the procedures that they have to be able to claim back that chargeback. I know I'm using a lot of technical language, but if you're in the industry, then you know exactly what I am saying. So these are some of the risks that we are seeing. Of course, I've spoken about social engineering, and I've also spoken about phishing. So phishing is where an email or any kind of comms is sent, looks legitimate, people click on the link, and then it ends up as an attack. And this kind of attacks, you can find that are targeted to corporates, or they're targeted to SMEs, MSMEs. It's not a one-person kind of attack. It's gain entry and then manipulate the entire system. So you have things like this, you have hacking, as I also mentioned previously, and these are some of the trends that we're seeing in the industry. So as we create our frameworks in the business, and as lawyers, and we are here to advise our clients, what are some of the things that we need to think about as we come up with these frameworks? And it's out of these frameworks that we will come up with the terms of engagement, or the contracts, or the terms and conditions that we give to our customers, depending on who your customers are. As I mentioned, we have a lot in the B2B space, and we also have a lot in the B2C space and the B2B2C space. So some of the things that we need to consider as we come up with these frameworks would be, we need to consider what are the dispute resolution mechanisms, and I'll start with the one at the bottom, because if a customer has an issue, what are the avenues that you've put in place in order to be able to handle customer complaints? And this makes it really, really easy for you to be able to stop some of the issues when the issues are happening. So if you have probably a call center where customers can be able to call, you have an email where customers can be able to send emails, you have an escalation matrix in your agreement that if you don't get this person, then you can get this person. That's for the B2B type of clients, to be able to allow customers to be able to raise their grievances. And sometimes you also get that when customers have an avenue to raise their grievances, it also becomes like your first line of defense, where if you didn't know something was happening, if a customer raises the concern, then you're able to know something is happening in our systems and maybe quickly have a look at it and see how you can be able to resolve. We also have regulatory compensation requirements. These are fines and sanctions. We never really want to get there, because by the time you're getting there, then the regulator has an issue with you, and you're also facing reputational risk from the industry. So avoiding regulatory fines and sanctions is one of the core roles of in-house counsels when we are handling legal and regulatory for our companies. Then we have contract-based risk allocation, where what risk can you be able to mitigate using contractual terms? So what kind of terms do you put in your contract to ensure that you can be able to reduce your risk? And this we talk about, especially contracts with vendors. So if you have a vendor who's providing you a service, you have a vendor who's providing you a system, and you have clauses in there that say they're not liable for anything. So where do you go when their system causes you loss, or when your system causes you some type of reputational damage? So you need to be able to look at your agreements and the frameworks that you have to look at what can you really minimize or mitigate using the contract. Of course, the contract at the end of the day is a document, but it's better for you to safeguard yourself using policies, processes, systems, and then your contract becomes your last line of defense. Okay, this has happened, indemnify us. Okay, this has happened, how do we handle it? But there's a way that you can be able to mitigate your risk so that even your vendor knows that should this happen, I'll be liable up to this extent. So maybe then you have them also paying more keen attention on the service or the product that they're offering. You also have agent and merchant conduct, and this is where you come out with SOPs, standards of operating procedures, where you say if you are to become an agent of my service, then these are the terms that you need to comply with. You must do this, you must do that, you must check KYC, you must. So all the musts that you're supposed to put under your terms of reference or terms and conditions for merchants and terms and conditions for agents. And further than this, you also go an extra mile and train those merchants and agents. So in M-Pesa, we do train our merchants and agents at least twice annually. And we try to also get them to also give us feedback of what happens in the market, what are they seeing, what are the industry trends, because they engage with customers on a daily basis. So you also use that avenue as you're conducting the training to be able to also get feedback from them and see if there are improvements that you can make. I've already talked about provider liability, and this is where, of course, you're using a vendor to provide you with something. Up to what extent can you be able to hold them accountable or liable when what they do or fail to do causes you loss? And I know most people in these negotiations, in agreements, the vendors would not want to take up any liability. So you try and cover that when someone is bidding for work. And you also try to ensure that you work with people that are reputable. So currently what we do is that we ensure that all our vendors also take up like the necessary insurance that they need to take up to ensure that they are covered. Because let's say, for example, you have a loss of $100 million, it might be very difficult for them to cover that out of their cash flow. So then taking up some form of insurance and mandating all your vendors to have that in place gives a bit of comfort, because should there be an occurrence, then they can be able to claim it from their insurance and not go out of business. Then both of you can meet your obligations. Of course, on the last end of the scale would be customer negligence. And this is on issues of social engineering, fraud, people who share their PINs, people who don't keep their authentication details safely or safeguarded, and then they end up being compromised and the fraud ends up happening. So a lot of customer education is key, depending on who your customer is, on campaigns that you can be able to do to teach customers on how to use your products. Because as we sit down and we look at ways to mitigate and avoid fraud, the fraudsters are also having their own conventions to talk about the new emerging areas, and that's their job. So they're primarily focused on how can we be able to get money out of genuine people. So the more that you have customers, then you have an obligation to be able to train them. You have an obligation to be able to carry them along, educate them. When you notice something that is happening, be the first one to tell them, so that we can be able to safeguard your customer and also have high trust in them. So as you're looking at your merchant agreements, and I saw a couple of questions on the Q&A tab, what are you supposed to consider? If you operate cross-border, which we do, you usually pick your main, which I'll call it like a HQ. Where's your HQ? Where are your systems based? Where are majority of your people based? Where are your customers based? So if this is where you start, maybe you start in Kenya and then you want to expand in Uganda and Tanzania, then when you start in Kenya, you tailor make what you have to Kenya. And then when you go to Uganda, you customize what is required for Uganda. So there are expansion markets and then there are operational markets. So you would definitely tailor make what agreements and terms and conditions and references to where your operational footprint is, and then your expansion becomes much easier. There is no way for you to be able to cater for all the laws that are there across 54 countries. Let's say you operate in the entire of Kenya, or you're targeting customers anywhere in Africa. You then have to pick and choose how to be able to get a neutral base and say that this is neutral for me. So you can choose, maybe, for example, in terms of jurisdiction, my jurisdiction is going to be laws of Kenya, or my jurisdiction is going to be laws of South Africa, or my jurisdiction is going to be laws of UK. I don't know why we go into UK when you're operating within the continent, but it's where we are. So you're looking for neutrality. What is neutral for you? Maybe you're operating in Africa, but your head office is incorporated in Dubai, or your head office is incorporated in Singapore. So as you look at what laws to apply, you then look at what is your operational base and where is your expansion base. Then form agreements, terms and conditions references across your operational base, and then expand outwards. So you have some items to consider as you come up with these merchant agreements. Of course, there are some that are regulatory mandated, and there are some that are contractual or best practice or preference. So of course, you have to talk about money. What are the costs and the fees which have to feature in the agreement? You also have to talk about what are your payment processing and settlement terms. So you'll settle T plus what? Is it you'll settle real time? You'll settle T plus 1, you'll settle T plus 2, you'll settle T plus 3. What are your settlement mechanisms looking like? Do you need the people that you're working with to also have bank accounts in country? Or are you going to settle people with bank accounts wherever in the world? And then what are the timelines for that? You also have fraud and chargeback allocation. So what happens during a chargeback? How much money do you hold to be able to secure the chargebacks that come through? What does the scheme say? So if you're processing Visa transactions, what does Visa say about chargebacks? What does MasterCard say about chargebacks? And then find neutrality to be able to not have a contract that says for Visa, it's this, for MasterCard, it's this, for M-Pesa, it's this. So you just have a neutral playing ground where you've tried to fit everything into one, and all of it is compliant. Then you also have data protection and confidentiality obligations. Of course, Janet has talked about data protection for in depth, so I won't go into that, but this must feature in your agreements. Then you also have termination and dispute resolution clauses. So what are the grounds for termination? What are the timelines, the notice periods? What are the consequences of termination? What happens after termination? And this also goes into data. What do you do with the data after termination? And then what is your transition period during a termination? So if you're using a system from someone else to someone else, then if I issue you a notice, what is the termination period and what happens when I want to terminate? Maybe you're moving to another provider. So you need to capture these clauses within the contract so that at the point of termination, that's not the time when you're coming to discuss with this person who does not want their contract to be terminated. And then you end up in a deadlock. You can't move, you can't migrate, you can't implement a new system because you didn't capture correct terms in the contract. You need also dispute resolution clauses. How do you resolve disputes that occur? I usually advise people to do the 3-step dispute resolution. So you have good faith negotiations, then you have an escalation for good faith. So you can have maybe the senior managers come in, they're notified of a dispute, there's a timeline to resolve that dispute. If the dispute is not resolved within that timeline, escalate it to the most senior people in the organization, give a timeline for that. And then if that one now is not, there's no resolution that has been reached, then move to ADR, move to alternative dispute resolution mechanisms. You can either do mediation, arbitration, whichever applies to you. And then, and only then, if required, then you move on to litigation. This ensures that there is some expediency in resolution of disputes. It also gives the business a commercial angle to be able to resolve disputes commercially before we now go on the legal side. And once something goes to litigation, it becomes public knowledge. So you really try to avoid litigation as much as possible. Okay, consumer protection issues, I think you can see that on the screen. Maybe I won't have to go into that just to save on time. Then I've spoken about dispute resolution, cross-border and emerging risks. So here you have issues like regulatory fragmentation. So you might have a law in Tanzania that says one thing and a law in Kenya that says one thing. In Tanzania, currently, we are facing an issue of data residency, where Tanzania doesn't have a very high appetite for cloud-based solutions, especially where that cloud-based solution is not hosted in country. But if you're looking at running an East African business or an Africa business, then it becomes fragmented for you to be able to host some systems in country and host some systems in the cloud. And we all know the benefits of having some systems in the cloud in terms of speed to market, in terms of enhancements and improvements, where you just build once and deploy multiple times at once. So you need to look at what the various laws in the countries that you want to play in or operate in are, and where is it that you can build concessions and where is it that you can make some compromises. Relationship is what we keep talking about. When you're talking to your clients, make sure you've developed the necessary relationships. So you should have relationships with all the regulators for all the countries that you're working in. If your client is going into a jurisdiction that you do not operate in, find a professional colleague there who has built the necessary relationship so your customer can be able to benefit off that and be able to go to market as quickly as possible. In the advancement of AI, I can just quickly Google what is the strategy of Coventry's for this year, and AI will give me the answer. So the question is not now, we're not trading in information, we're trading in speed to market and the style and the strategy around how do you approach your customers. So if you don't have the relationships and you don't have the know-how or the understanding of a market, and you want to be the only one to do it for your client then loses out on that speed. So you really need to leverage and rely on the relationships that your other professional colleagues have created, or create a Pan-African business that you can be able to serve people anywhere. You have people sitting in Tanzania, you have people sitting in Uganda, although this is a very expensive type of operational cost. So other than that, we have AML inconsistencies, where in other countries, maybe when you're sending a transaction, you're required to send a transaction including name, age, gender, and originator of the transaction, and then somewhere else you're just required to send name and a unique identifier. Previously, there's a deployment that we had to do in our Lesotho business, where the regulator came in and said that for all IMT transactions, which are international money transfers, these are FX transactions coming out of that country and coming also out of Africa, that one of the fields that we have to include of the person who's sending the funds is the gender, and we also have to include the gender of the recipient. And then, now most of the guys who are sending money there were in the diaspora, where you have not two genders, but you have a myriad of genders, and Lesotho only recognizes male and female. So you have nuances like that. And then now, how do you go about them to ensure that you still comply, but your business still operates? Because you might comply on the side of Lesotho, but on this other side, then you are offending some of your customers on this side who are originating the transactions. So it's just good to find a good middle ground. And again, I'll say relationship, where you're able to get a sit down with the regulator, explain to them, this is where we are coming from, these are the type of customers that we are serving, and be willing to co-create together with the regulator to suit your operating environment. Then we have tax and currency issues, and this is a big one. This is a really, really big one, especially like if you operate in some of the tax-heavy jurisdictions that we have in East Africa. And there are so many tax considerations to consider. You have issues of transfer pricing to consider, maybe depending on the structure that you have of your organization, where you have a holding company, then you have subsidiaries, where the subsidiary is situated. You have contracts between this subsidiary and this subsidiary to facilitate a leg of a transaction. How do you charge each other in terms of one subsidiary to another, and what does the law say about it? So transfer pricing is a big one, and from all the audits that we usually see the taxman coming to do, and this is not just in Kenya, but throughout the African footprint, sometimes you think that you've done the right thing, but then an audit comes and someone takes you back and says, I'm auditing you for FY 2022, 2023, comes back with a bill that you did not foresee in 2026, and you have to cater for that provision in your books, which sometimes ends up wiping out the profit that you declared that year. So tax is a big issue, and lawyers were not tax people. So it's good to always advise your customer or your client or your SME or your MSME to get a tax person to look at their issues. Unless you're a legal tax expert, then we really need to rely on the experts on that side of tax. Currency, of course, there's FX. Sometimes you structure your business well, you gain a lot from FX gains. You don't structure your business well, you lose a lot from FX losses. So those are also other considerations to make. Then we have new models that are coming in. Of course, AI is a big thing that has come in. We have buy now, pay later kind of models. We have CBDCs that have also come in, stable coins that have come in, and what do you need to be in the lookout for? So sometimes you have a customer step into your office, they're talking about issuing stable coins, you've never heard of stable coins as a lawyer. How do you keep yourself abreast of the emerging trends, especially if you decide that I'm a tech lawyer or I'm a payments lawyer, then you need to keep abreast of the emerging trends that are coming in. So my last slide is on practical legal recommendations. And this ones I would recommend that we really work on like governance structures. What are the governance structures? Some SMEs, MSMEs are usually like a company that started, maybe two guys were developing, and then they developed something and they notice it is something they can sell. Then they start selling, then they realize, oh, we need this person. Then they keep adding depending on the need. So the lawyers usually come last as the people who are added, if at all they are added to be part of the team. So you might find there's an in-house, or you might find there's no in-house and they're still using external counsel, which means that there is really no documented, vetted governance structure. So immediately you come in and your client has come in, your first question needs to be, what does your governance look like? So even for the development you have done, what are the structures around how you develop, how you deploy, where your things sit? The first speaker spoke about IP and trademarks. Fine, you're saying you're selling this thing. Have you protected it? So governance structures are really, really important, and just question them. So when you have a customer who's coming in, those are the first things you want to see. Ask for the documents, look at them, vet them, review them, guide them, audit them, ask them. Like governance is what a company stands on. Any company can start something and become a big thing, but how it becomes sustainable is based on governance. So I cannot preach so much about governance. So conduct regulatory mapping. This is where you look at, this is, as I said initially, this is your operating landscape and this is your expansion landscape. So in your operating landscape, what does the regulation say? Create like a rule book. No, these are the rules that affect our business. How are we compliant according to these rules? And it's okay to start at zero, but you know them. Then you're able to prioritize and say within the next 3 months, within the next 6 months, we're going to improve our compliance here, and then create a roadmap. Okay, and this should be done in conjunction with risk, where you're looking at what are the risk factors, what are your operating environments, and then now you create a roadmap and you start implementing that roadmap. You also need to strengthen your contracts and your risk allocation. So maybe you've been using the same contract for a while, give it to an external counsel, let the external counsel look at it, because they look at a lot of agreements in the industry. They also track what is going on in the industry. What are the kind of cases that they are seeing? What are the kind of emerging issues that they are looking at? If you don't want to pay external counsel to draft for you the contract, at least pay them to review and update your contracts for you. And this is an exercise that you can be doing, even if it's twice, once every 2 years, once every year, depending on the budget that you have. Look at some of these things. Also, you can implement compliance frameworks. I think that is going towards also the governance structure, and you enhance your fraud responses. So under fraud, always work with a system, and then people become your second line of defense. So implement systems that can be able to detect fraud, implement systems that can be able to mitigate the fraud, and then treat the fraud. Because if a fraud is happening at night and all of us have gone to sleep, your system needs to be able to be the watchman and do what is required. And then when people come back in the morning, they can be able to look at what did the system do. It's easier for you to correct the system after the matter, other than to put it as people-led, where someone has to approve the system action. So you train your models. Now we have AI, we have machine learning. Train your models onto the kind of trends that you're seeing. And the more that you train them, the better and efficient they become. We were doing a hackathon internally, and one of the teams in our fraud teams came up with a model in the hackathon that detects the fraud before the fraud happens. So these are some of the things that AI is giving us advantages that we can be able to advise our clients to use. We also have to embed dispute resolution mechanism, embed it in your process. So this is the way of handling customer complaints. If there's an issue with one of our providers, this is the procedure, this is our escalation matrix, etc. And make sure that it's a framework and everyone understands, especially people who have something to do in the levels of dispute resolution that you have. And then lastly, to implement the advancements in technology to prevent, mitigate, and treat fraud, compliance, and legal risks. So how can you use AI cutting across everything that you do, and also enabling your customer to do the same? I think I can stop it there and then hand over back to Ellie for any questions. But thank you for having me, and it's been a pleasure to be part of this webinar.
Thank you very much, Julie, for that great presentation. I note we have only some less than 20 minutes or so time-wise, so I'll just quickly go through a couple of questions that have come through the chat. If there are any more questions that any of you have that you'd like to pose to the panelists, please do so in the chat and in the Q&A, and we'll hand them over to the panel to address. But just to kick us off, and I can see this is one of the things raised in the Q&A, and it's an issue that has been facing a lot of businesses, especially MSMEs, and this is a question of balancing the compliance burden that these businesses face in terms of the law with the actual costs that a small business is able to deploy towards addressing these compliant issues, especially in the growth stage. And I'd like to twin the question so that both Janet and Sunday can give us their view on it. First of all, from a data protection compliance perspective, in terms of collecting consent, in terms of addressing issues around cross-border transfers, etc. And the twin of that question will go to Sunday in terms of business costs towards trademark protection risks, platform registration, domain registration, etc. versus, the risks that the business can face should they not invest these funds towards compliance and protection. Perhaps, Janet, you can go first.
Consent management. Consent management still remains one of the biggest challenge that businesses have. This is because consent needs to be proved. It needs to be evidence verifiable by the regulator and even by the data subject. So when you're saying you got my consent, you should be able to show me how I gave you my consent. Was it a signature? Was it an opt-in command? Was it a yes, a click button? Do you have a timestamp? Do you have a back-end configuration to show when exactly I opted in? And even if I chose to opt out at some point, if it's digital signature, where did you collect it? Where do you keep it? If it's a manual signature, are you able to show evidence of such? And because consent comes with the highest obligation for any data processor or any data controller, it's one of those situations we try to avoid and say, if you can go with any other lawful basis, use that, and then consent should be the last one. And this is because of the burden of proof attached towards proving it at any given time. Then that means on the back end, you need to maintain something called a consent register, where if I ask for when did I give my consent, you go to the register and you're able to pull it out. And this register is usually in digital or manual format. And then now when it comes to cross-border transfer and cross-border, The good thing with East Africa is that we sort of implemented or enacted our laws one after another, and they are all based off what the European Union GDPR are about. So they're not too alien and not too different from each other. So the obligations in terms of transfer of data, but also the other obligations on data handlers is more or less the same. But the only challenge that we have as a region is that the enforcement mechanisms may not be similar. The market nuances and the business nuances for each regions may not be similar. The advancement of the law in the regions may not be similar. And so even as you're transferring customer data or data subject data, the other thing you have to ask yourself, if I'm transferring it to a country within the East Africa region, am I able to enforce my rights as a data handler? Am I able to enforce, are my data subjects able to enforce their rights? And is the regulator cooperative and approachable and robust to be able to enforce and provide a good environment for me to transfer this data? So transfer of data now is moving more from it being a legal decision to now also being a commercial risk or a commercial decision for businesses to be able to know what are some of, yes, we appreciate the legal risks, but what are some of the commercial risks from a geopolitical perspective that may be attached to transfer of this data. And these are the discussions that you won't see in any regulation, but they exist in any marketplace. So again, those are the dynamics we are seeing with the transfer of data. Like Julie said, there's a lot of discussions about sovereignty and localization of data, and most of them are hinged on commercial decisions more than regulatory decisions. So those are some of the things, and those are some of the questions that you have to ask yourself if you're using consent at any given point, and then you're transferring data outside your jurisdiction at any given point. I'll pass it on to Sandy to answer the other part.
Hi, Ellie. I think I missed out on the question. What was my part? What did you want? I missed out on that bit.
I think Ellie wanted the risk.
Sorry, I was unmuted. The question was around balancing compliance and protection costs for MSMEs, especially at growth stage. And on your part, it was around the costs of trademark protection, platform registration, domain registration, etc., which can be costly vis-a-vis whatever risks might arise from not getting the necessary compliance and protections.
All right. So we have talked about risks in terms of not complying, but I think what is pivotal in terms of costing for cross-border registration of trademarks, patent, or IP assets, it's pivotal for us as practitioners to give options to our clients. For example, telling them that there is an option that they can go through Aripo, which is cheaper than going and filing individually, let's say in Tanzania or perhaps in Uganda. For those members, I think there are about 13 members, or going towards OAPI is cheaper than spending, let's say, 1,000 USD for filing a mark in Uganda, of which under Aripo, designating one country could cost you about maybe $200 to $300. And then perhaps across all the 13 countries, it could cost you with legal fees, perhaps not more than 5,000 USD, of which if you had to go to each would have costed you 13,000 USD. So I think it's in terms of risk of not crossing border and protecting your IP asset, would have been better for us to tell them that cost-wise, there are other options. And now we have the AFCA that is coming across. This is going to put this whole platform that is going to serve the ecosystem as far as MSMEs are concerned. So I'll say from the costing perspective, we should give them options which works for them in terms of these regional blocks that are offering, perhaps as far as IP registration is concerned.
Thank you very much. I can see another question, which I think would best be directed at Julie, concerning the liability for cross-border digital payment failures or fraud and how to allocate risks between platforms, businesses, and consumers. I know you touched on this during your presentation. Therefore, I would appreciate, as you answer, if you could also add some more information on a point related to that, which is specifically the information asymmetry that most users of these payment systems have. This is in the sense that there is not much transparency around the transactional flows with the payment systems, the documentation, evidentiary material, etc., that will allow a third party to place the burden of loss on this one person or another, whether it's on a system failure or insider fraud or an agent or a merchant. All that information is in-house, and me as a third-party consumer does not have that information. So how do I address that problem when I'm trying to get some redress around some fraud, some lost funds, etc.? Especially sometimes, unfortunately, when the payment service provider themselves are being rather lacking a lot of transparency during follow-ups.
Okay. This is a bit complex. So there's the element of the cross-border nature of the transaction. So you have maybe a transaction has originated from somewhere else, it is being terminated somewhere else, and then you have different players. If I can use the examples that have been given in the question, you have the platform, you have the business, and you have the consumer. So you might not know where to place the liability, but I'd always start at where was there a lapse? Okay, how did the fraud take place? So did the fraud take place because the platform was compromised? Is it the business that was compromised, or is it the consumer that was compromised? So if you're able to determine what was the point of compromise, then you're able to also determine where to place the liability. And how you distribute it in the contract is usually just to have a liability provision that says that whoever bears the liability is the person who failed to do their obligation or was negligent in performing their obligation. So once that is included in the agreement as part of the liability provisions, then it's easier for you to follow up on it. I know it's easier said than done, especially where the consumer is the one that has experienced the loss. And sometimes the consumer is the person who was compromised, but the consumer will never come and say they were compromised. And at the point when the consumer is compromised, with this digital age that we have, you have someone who's already gone on social media to say, probably I've lost money here and here and here. Then now you're also facing reputational risk. And when this happens, most businesses then go into panic response, where you now want to resolve that issue for that particular consumer without really interrogating what really happened. So it's good to interrogate where was the point of compromise, audit the transaction, and also you're able to find out, is there a lapse that you're not aware of? It could be just that one consumer who was compromised, and it's something that is much easier to contain. But if you have a whole segment of your consumers that are compromised, then there's an issue either with the business or with the platform. But I'd say always start out by knowing there are different players in a transaction or in a business, and therefore you need to be able to allocate liability depending on where the compromise happened, on either who was negligent or who failed to do what they're supposed to do, and cover that as a general clause in the contract. Then at the point of implementation, to look at where the point of compromise is, and then allocate the liability accordingly. I hope that answers it. Thanks.
Thank you very much, Julie. we have another question surrounding dispute resolution in cross-border digital contracts, especially where dispute resolution mechanisms are different between jurisdictions, and there are questions of differing technical capacity and jurisdictional issues. Unfortunately, it seems to be a litigation question thrown in the midst, but I'll hand it over to Janet to address it for us.
Ellie, do litigators have a particular look? So I'll build off from what Julie said. Whenever you're negotiating these contracts, the dispute resolution clause and the governing law clause are usually some of the biggest pain points for anybody entering into such a contract. And it depends, because sometimes you have the person who's supplying as a big tech based in the Silicon Valley or based out of the jurisdiction. And you have the consumer being a local company or a local fintech company. And those are usually the hardest, because the supplier, if they are a big technological company, will want to impose what it considers best for it and what it considers as its global practice. So you have them saying that you'll be subject to the laws of their host country or incorporation country. You will have them saying that they are subject to the courts or arbitration procedures of their local country. Others try, and you can push back, others try and always opt for neutral laws. So they might say, even though the governing law belongs to their country or their host country, they might choose a neutral location as the place for settling this particular dispute, so that they don't do their local courts, but they might choose the International Chamber of Commerce, or they might choose a different neutral country with arbitrators appointed from neutral jurisdictions to actually hear this matter. If you're dealing local to local, again, it depends with what is the practice and custom of your judicial system. I'll speak for Kenya, and I know within the Kenyan judicial system or the court system, they can be quite slow, quite aggravating, but also grasping the technical issues that are raised by some of these contracts becomes very hard for some judicial officers. And so we do not have specialized courts within the region where you can say that this is a specialized court that handles tech matters. So you have to rely on the judges with either the precedent law they have, their researchers, and their knowledge of some of these things. And a lot of these things get lost in translation. If you opt for alternative dispute, which is a local arbitrator, you can always opt for an arbitrator who has the technical expertise. So not necessarily a legal mind or an advocate, but you can opt for somebody with a tech background, somebody who's been in that particular business, who understands the business. If it's one of those technical contracts, again, I'd say look at having a bench of arbitrators where you have two professionals from the legal sector and one professional from the tech sector to kind of break the tie. But if you're going to be dealing with international companies, international service providers, always push back and try to have a neutral location in terms of alternative dispute mechanism, and don't subject yourself to the courts of their land. Adopt an alternative dispute resolution mechanism. Choose a neutral location to both of you, because you're also looking at the cost implication of it. Then if they do insist that they're going to rely on the laws of their country, then that means you have to hire, if it's a UK Commonwealth sort of thing, you may be safer, but you may need to hire a lawyer or a practitioner from UK. If it's US, then it means you need to retain counsel from the US to lead this sort of discussion. Again, you're looking at arbitrators' fees. So it all boils down to a balance of what is the list of the legal exposure to you, jurisdictional-wise, law-wise, but also from a commercial perspective. If you're looking at a claim for several $1 million and you're looking at the arbitrator's fees and traveling to this location, it's also another several $1 million. Then I'd suggest you enter into sort of either mediation or good faith negotiation, and you can tier it because a lot of them tier it so that you have the project managers being the first line of dispute resolution. Then you move to probably the CFOs, then you move to the CEOs. And when the senior management cannot be able to untangle this issue, that's when you move to the alternative dispute resolution by external sides. But if you can manage it internally, because you're also looking at reputational and commercial exposure, then I'd suggest you exhaust that with specific timelines, because some people can also drag these disputes for months. So give specific timelines, manage it internally. If all fails, then look towards external management.
Thank you very much, Janet. Seeing we are a bit pressed for time, I think I can just ask a final question before we close the session. That is briefly, what do you think is the next frontier in the respective areas you have discussed? I think Sunday put it quite clear in his presentation around the challenges that AI is bringing out to intellectual property and trademarks and their protection and some gaps in the law. So perhaps if Janet, you could let us know what the equivalent area is around data protection, and Julie close for us with the same on fintech and mobile money payments.
Mine is just one sentence: artificial intelligence. The next frontier we are seeing in the world of data privacy is how artificial intelligence will disrupt and how it will be embedded within the data privacy practice space. So that's what we are looking forward to. And also just seeing what now regulators will do in terms of more enforcement mechanisms. So that's what is our outlook in the market.
Julie, kindly close for us.
Okay. Not always nice to be the last person and holding people between you and 4 p.m., but I'll try and be brief. So I think in terms of the tech and the payments industry, the next frontier is just, as I said, speed to scale to market. How can you be able to scale to market, go to market, and scale your business well, while still ensuring that your governance is intact for your business to be able to be sustainable? So those are the things that we need to look at. And as lawyers, we also need to advise our businesses for our businesses to consider. We are seeing a lot of disruptions coming in. Google Pay launched Google Pay last week, and we are now seeing that coming in. Apple Pay is already in play. It's just that it hasn't been switched on. So as we are looking at, maybe my biggest competitor today is M-Pesa, or my biggest competitor today is KCB, there are other guys that are coming that might disrupt the entire industry. So it's in how we collaborate, even as we compete in the business, to ensure that the African players in Africa, who are the ones who know the specific needs of our customers, are cooperating to be able to create a good industry before the industry is disrupted. That I would say is the emerging trend. And just to answer the question on someone who asked, the important thing to consider in a cross-border transaction in terms of a business or a company that has branches across the region, the best way that you can be able to look at this is, where do you want to operate from and where do you want to expand to? And then what regulations and laws are favorable to what you'd like to do? So always start where you're favorable, what is favorable to you, and then what is your addressable target market? Where do you think you can grow? Where are the majority of your customers at? And then now move from there, even as you advise the business, but just what is palpable and what gives you the most width to be able to expand. Yeah, I think I'll close it at that and hand it back to you, Ellie.
Thank you very much to all our panelists. It's been a pleasure listening to you this afternoon, and we have gained quite a lot of knowledge, information, and getting up to speed with what the trends are in this sector. So thank you very much to Sunday, to Janet, to Julie. We really appreciate the time that you've taken here with us. I'll just like to hand over back to Gabriel to close the session for us. Thank you very much, everyone.
Wow, thank you, Ellie, and our esteemed panelists, Mr. Sandenda Mugoba, Ms. Julie Ojaya, and Ms. Janet Otero, for that very wonderful but insightful session that you've given us this afternoon. It's always a pleasure to host you all and to learn from you each passing day. On behalf of our entire team, our CEO, our president, Mr. Ramadan Abubekar, would like to thank you for your continued service to the society and for always making a time to be a huge part of our ongoing initiatives to build capacity of members across board. Friends, a recording of this session will be shared with you along with any presentations that have been made this afternoon at the tail end of this session. So thank you all so much for making time. Now, this Thursday, we have a session hosted by our Women Lawyers Committee, and we'll be discussing building a female talent pipeline in East African law firms and legal departments from strategy to business imperative. That will be happening on Thursday, 18th of June, 2026 from 2 to 4 p.m. So you want to catch that session if you're interested in building a female talent pipeline within the legal profession. Also, on behalf of the East Africa Law Society Institute, we would like to announce the inaugural negotiation and leadership masterclass that will be happening from the 13th and 15th of July 2026 at the Kigali Marriott Hotel in Kigali, Rwanda. And this masterclass is held in partnership with the Sing Academy. Now we have a whole huge host of experts on negotiation and leadership that will be coming in all the way from US, but from across the continent as well to discuss leadership and negotiation. So if you're a thought leader out there, you're an in-house counsel, a private practitioner, a judge, or even a corporate executive working in the corporate space, please do catch our 5-day masterclass series happening in Kigali, Rwanda. To sign up for the masterclass, please visit us at www.ellawsociety.org or write to us at info@ellawsociety.org for more information. Friends, it's been a wonderful afternoon discussing these nice and pressing issues with you. We look forward to hosting you once again. Stay blessed until we meet again. Goodbye. Thank you.
Thank you, everyone. Goodbye.
Goodbye.